Good morning and welcome to the virtual fifth DCA. My name is Scott Makar. I'll be presiding over today's case. With me, we have Judges Joe Boatwright and John McIver. We have one case on our docket today. It's 24-2030. Jatef, hopefully I pronounced that correctly. Correct me if I'm wrong. Versus Mack and Halifax Paving. There'll be 20 minutes per side. Counsel for the appellant, are you ready to proceed?
Yes, Your Honor.
And how much time would you like to reserve for rebuttal?
5 minutes.
All right, very good. Please proceed.
Thank you. May it please the court, Shay Moxon on behalf of the appellant Tiffany Jatef. My briefs go into a lot of detail, so I'd like to start with the 10,000-foot view. The Florida Highway Patrol is not a road construction business. Its troopers are not road construction workers, and a request for off-duty police services is not a contract for road construction work, and that includes the request in this case. And for those reasons and all the others that I'm prepared to discuss today, FHP was not a subcontractor on the road construction project where Ms. Jatef was injured, and that's why this summary judgment must be reversed. And I'm sure the court's familiar with the facts, just brief refresher.
Counsel, if I could interject, at this point in time, who is paying for the medical expenses?
I don't know who's paying them now, but she has received workers' compensation benefits for, I believe, time off work and for at least some of her medical expenses through her workers' compensation coverage with FHP. So it's paid by the state essentially. That's in one of the interrogatory answers. So
does that hurt your argument anyway, that she's receiving benefits from FHP, that there was not a contract between FHP and Archer? Otherwise, shouldn't Archer be paying these benefits if she was working solely off duty for them?
Well, I believe it helps our argument. It establishes that she's been deemed to be in the course and scope of her employment as a law enforcement officer with FHP at the time that she was injured. And you compare that in contrast to this request for police services, in which Archer checked that it was not going to provide workers' compensation coverage for off-duty troopers performing security work. You put them two together, it all points in the same direction as everything else I'm arguing, that at the time Ms. Jatef was injured, she was working as a law enforcement officer in the course and scope of her employment with FHP, and not as a road construction worker, and was not considered to be a subcontractor by Archer. And
so the contract itself between Archer and DOT provided that Archer was to complete all labor necessary to complete the project. So as to your opponent's argument, why isn't traffic control part of that project to complete a road construction project like this?
Well, there's nothing in that contract that specifies traffic control or lane closures. And
so you would agree, if that contract was a little bit more specific with FHP, that FHP could potentially have been a subcontractor in this case?
Well, there's also the problem that this request for police services is not a contract, which has been...
Well, I understand that, but if the contract was more specific, you don't disagree that if it had been more specific, that FHP could have been considered a subcontractor, as they don't have to actually be doing the actual road work. Traffic control would be part of that project. Do you disagree with that?
Yeah, if there were facts in which there were contractual obligations that Archer owed to FDOT in that contract, and that matched what is in this request for police services, and the request actually were a contract, which it isn't, yes, then the defense would be on better footing, but those aren't the facts that we have here. Also, there's a new, as I was
Do,
preparing for,
do the things that are expressed in the contract contain the things that are implicitly necessary to complete the contract? Or do you actually have to mention every constituent action that takes place that supports the final project?
well, I, on that question, I think that the case law is a good guide for this because, for example, the main case that we rely on is the, oh, now it's slipping my mind. I got to look at
Is
the
that the
main.
Cicerone case?
Yes, Cicero versus Sunbelt Reynolds. Of course, the two subcontractors who hired the equipment rental company, they needed that company's services to do their work. They needed their scissor lift, and some of the services that the rental company provided were done at the work site.
Well,
Delivering.
what do you say to the Appleese argument that the Sunbelt and Cicerone was just a supplier of equipment versus, in this case, the trooper was an actual participant in the work on the project?
Well, it's that the equipment supplier in Cicerone did a bit more than just supply it. It was also responsible to repair the scissor lift on site if necessary and to train employees of the subcontractors in using the scissor lift. I think another important fact here is that the reason why troopers were required to be there for certain lane closures was because certain regulations required it. And as I discussed in my briefs, an obligation that is imposed by statute, and this would extend to regulation, is not an obligation imposed pursuant to a contract that could be in which where the subletting of that obligation would create a contractor-subcontractor relationship. And some other examples of where just because a service was necessary for the project didn't make the provider of that service a subcontractor. This court's case in Adams Homes of Northwest Florida v. Cranfield. In that case, it was that involved a material supplier, a supplier of roofing materials. And the court held that that supplier was not a subcontractor, even though their employees delivered the roofing materials all the way up onto the roof itself. There's also the Mathis case, which appellees cited in their brief, and I might have cited it in my reply brief, where a clinic hired a cleaning service. It is a health clinic. Now, of course, a health clinic needs its rooms cleaned to be able to do its job, but there was nothing in that. There is no evidence of a contract between the clinic and its patients that imposed an obligation to have the rooms cleaned. And so those are examples that I believe show that just because a service is going to be necessary for a contractor to do its job does not suffice to meet this requirement that to create a contractor-subcontractor relationship, the subcontractor has to sublet an obligation that is imposed on that contractor in the contract between that contractor and the third party, in this case, Archer and the Department of Transportation. Also, the Galoo v. Clopay case out of the 3rd DCA, which I cited in my reply brief, that discusses how the obligation to be sublet has to be an obligation to perform a job or provide a service. And not just that, but to perform a job or provide a service for the third party. So in this case, that would mean that the obligation that Archer sublet to FHP to make them a subcontractor had to be a service that that Archer had to perform for DOT. Well, looking at the request, it's talking about traffic control and providing a safe work zone for road construction crews. Those are not services that Archer was obligated to perform for the Department of Transportation.
What was Archer required to perform for the Department of Transportation?
It was to do these road improvements.
Can they do those road improvements without closing down the road? Or without closing down the lane, without making sure that someone's not driving through their construction site?
Well,
Can they do that?
I don't know. I mean, it's going to depend on the circumstances. I presume not. Of course, there are FDOT regulations that require lanes to be closed off in certain ways and that sometimes require a law enforcement officer to be there. But in this instance, or as I've discussed in my briefs and today, an obligation that is imposed by statute or regulation does not qualify as a contractual obligation. And also, as I've discussed in the reply brief, Miss Jadif and other troopers who took this duty, she was not personally involved in physically closing the lane. That was handled by Archer. They were putting out cones, light boards, some other ways to close off a lane are to put out barrels, warning signs. I believe, excuse me, I meant Halifax. Halifax, they put out warning signs. That was the closing of the lane. Miss Jadif, what she did was she parked her patrol car towards the end of this lane closure with the blue lights flashing as the regulations required. But she wasn't out there physically putting out cones and barricades and light signs. She wasn't doing the lane closure work herself.
Is anything you're discussing, is that raising did you raise below that there's a factual dispute here? Or is this just purely a legal matter?
It is a combination of a legal matter and a lack of evidence to support the defendant's position.
I mean, we're here on a summary judgment issue. So you're not arguing in your briefs that there's a fact. I mean, you seem to be arguing facts. You're not arguing that there's a factual dispute, are you?
No, there's no conflict. There's no conflicts in the evidence that create a factual dispute. We believe that the conclusion should be, as a matter of law, that FHP was not a subcontractor, and therefore there's no horizontal immunity. But at the very least, the defendants failed to present enough evidence to establish that there was such a relationship, a contractor-subcontractor relationship. So I submit either we're right as a matter of law, or at a very minimum, the defense failed to carry their burden to present enough facts to support their position and prevail on summary judgment.
Officer Jatef she was being paid by Archer Western, correct?
Yes.
So what if there was a direct contract between Archer Western and Officer Jatef, and we didn't have a request for police?
Well, that has never been considered or discussed or explored below. The facts haven't been.
But what if it were? What if, hypothetical, what if there were a direct contract with her to provide services?
Well, it would, then we'd have to look at what exactly those services were, what the terms of the contract were.
Same services.
Same services. If they're these services, no, our position is Ms. Jadif was there to provide police services, not to do construction work.
She basically was like a supplier who brought in scaffolding or something. They're not a part of the project, they're just a supplier.
Somewhat analogous to that, but also analogous to a security guard. And as we've cited in our briefs, there are a number of cases where a security company was held not to be a subcontractor because the purported contractor had no contractual obligation to provide security services. They might have had a common law obligation, a statutory obligation, but there's no evidence that they had an express or implied contract with their customers, be it the Holiday Inn guests or condominium residents, to actually provide them with security guard services. And so
if we affirm, let's just say we affirm what the trial judges ruled here, Officer Jatef will continue to get benefits from FHP. I assume here that because Archer Western checked the box, they're not providing workers' compensation, that she would not get coverage from them.
If she's still entitled to benefits, yes, and as I mentioned earlier, and that means that she's been deemed to have been acting within the course and scope of her employment with FHP. I'd just like to say, my time's getting a little short, but I just want to emphasize that besides the fact that Archer did not sublet any of its duties to FHP, another reason why there's no subcontractor relationship is that this request for police services simply is not a contract. It does not obligate FHP to do anything. It does not promise to provide any number of troopers. It does not.
Well, no, the request itself doesn't, but I mean, it seems as though there's follow-up conversation that happened between making the request and someone actually parking the patrol car on the site. And that continuing conversation ostensibly would contain offer acceptance, consideration, and would be a contract, no?
We don't know. We don't know because that was never argued below. Those facts weren't developed in the record. And this is why courts, including this court, have held that summary judgment cannot be affirmed based on grounds that were not raised in the motion below. So this theory that was suggested in the answer brief that perhaps there was some implied contract between Archer and FHP or Archer and Ms. Jadif that filled in these gaps, it can't be a basis for affirmance because it was not raised below. And I'd add that the trial court's order is entirely based on the premise that the request for police services was the contract between Archer and FHP that supposedly made FHP a subcontractor, and it simply wasn't. It didn't impose any obligations on FHP. It didn't promise that FHP would supply any number of troopers, and it lacks it lacks essential terms of a contract. And I'm into my rebuttal, excuse me, my rebuttal time. So unless there are any further questions, I'll pass it to counsel.
Okay, thank you. I'm going to add an extra minute to your time for rebuttal, and we'll give you an extra minute to you, counsel for appellate. So you may proceed.
All right, thank you. Thank you, Your Honors. May it please the court. My name is Michael Rodabaugh from the law firm of Clausen Miller, and I represent the appellees, Halifax Paving and Rodney Mack. We believe that this case is a straightforward application of the concept of horizontal immunity under Florida's workers' compensation law. And that is because there's two subcontractors working on the same FDOT highway project. Rodney Mack was an employee of Halifax Paving, who had been engaged as a subcontractor to perform paving work on the overall project. Officer Jadif, through her employer, the Florida Highway Patrol, was providing lane closure services.
Who do you claim is the subcontractor, FHP or Officer Jadif?
I think it's a distinction without a difference, Your Honor. I think pursuant to the request for off-duty police services between Archer Western and FHP, yes, FHP was the subcontractor.
So why did Archer pay her directly and not FHP? If that's the case?
I believe because that was the term of the request for off-duty police services. So
that's so if I look back at that request for services, it's going to provide terms of hourly rate, who pays who, those kind of things?
No, Your Honor. The request itself was not specific as to those granular
So isn't the request really just an authorization to allow somebody to work off duty if they want to?
In a way it is, but I believe
Does it bind FHP to provide these troopers? Does that actual request itself do that?
In practice, it does, Your Honor. In practice, it was a request made.
I'm not asking in practice. I'm asking from the language of the actual contract. Does it bind FHP in any way?
Not in any sense in that they're obligated to provide an X number of workers on X number of days for Y hourly rate. No, Your Honor.
And following up on Judge McIver's question, was there any evidence produced below at the summary judgment proceeding that there were other discussions that may go along with this contract, or is your opposing counsel correct that there was not?
Your Honor, there was certainly evidence developed that this request was made. It was executed by a master trooper of the FHP, and at the time, the Officer Jatef was accepted that request, that assignment to work alongside Archer Western and Halifax on the date in question. The record reflects that she testified that she was paid directly by Archer Western on the job site, and that she was assigned to work alongside Halifax Paving on the night in question.
So is there anything in the contract that actually goes to the actual construction work, that the request for services? Is there anything related to that contractual language?
Well, Your Honor, I believe the relevant language is that the FHP member duties and responsibilities section in the request itself, and that had traffic control, provide a safe work zone for road construction crews. That was the extent of the obligation that FHP troopers had. I would add that this request explicitly did not include the provision of police services. It was made in as a carve out to the request that these FHP troopers, when they were off duty and they're on site with these other construction workers, were permitted, if needed.
Mr. Rodabaugh,
Yes,
do Trooper Jatef's duties on a day-to-day basis include closing down portions of the highways not related to any other contract?
That, Your Honor, I don't know. I don't believe that's developed in the record.
Is that just something that they regularly do? Is just go out and close down and cover and make sure that a lane is closed and protected?
It very well may be, Your Honor, but I don't believe that's part of the record. I believe the record is clear that on the date of the incident in question, Officer Jatef was engaged in exactly those type of lane closure services. While she did not engage in the physical act of putting up the barricades and closing the lane, she was present at the end of that closed lane, that closed right lane, parked in her off-duty vehicle or trooper vehicle while she was off duty when she was struck by Mr. Mack's truck. And so the record is very clear that on the date in question of the accident, she was engaged in exactly those type of services.
Well,
that were...
here's the root of my question. If you're a supplier of construction equipment, your job is to lease and sell and deliver that construction equipment, and your maintenance of that equipment you're delivering to the job site is in furtherance of the thing that you normally do. Whereas if you're a trooper who's being hired to close down a segment of roadway for a construction site, are you being hired to do what you would normally be doing otherwise, or are you being hired to do some additional thing that you wouldn't normally be doing? Are you working in furtherance of your own normal duties, or are you working in furtherance of the duties of the contract? I think that's the distinction between, or that's the possible distinction between our case and the cases cited by your opponent.
Yes, Your Honor. I believe the case law all talks, and the statute itself talks about in this subletting analogy, where the statutory employer, the contractor, sublets a portion of its contractual responsibilities to the subcontractor. And if the subcontractor or its workers are engaged in those sublet duties that were that derived from the initial contract, then that's what creates the vertical relationship, the statutory employer relationship.
So you don't disagree that subcontractor is not defined here in the Workman's Comp statute, correct?
I don't believe it's defined as such, Your Honor. I believe some of the case law.
So we're able to look at, for example, dictionary definitions in order to define that, correct? To interpret the statute. You would agree with that, right?
Yes, Your Honor. I believe certain cases have done just that.
So Black's Law Dictionary, for example, defines subcontractor as someone who is awarded a portion of an existing contract by a contractor. So I'm not saying FHP couldn't have done that here, but was that done here? Was Trooper Jatef or was FHP actually awarded a portion of this contract from
Yes,
your
Your Honor.
request of services? So that's what you think your request of services provides?
Yes, Your Honor. It's because the Archer Western contract, the master design build contract it had with FDOT, it was a very large construction project, and the record shows this clear chain of contract. This was an expansive road construction project, and the scope of the master contract was appropriately expansive for that reason. And it required Archer Western to do all the work and furnish all the materials and labor necessary to carry out the overall scope of the work, which was essentially expanding I-95 and I-4.
Again, was FHP though actually involved in this, or did they just allow people to work in an off-duty capacity to provide services?
Your Honor,
I'm just trying to, it's hard for me to find that that's, I'm not saying this couldn't happen in this situation, but it's hard for me to find that that's actually, they were awarded a portion of this contract based on the dictionary definition. And I'm not saying there aren't other definitions that might support your position, but if you can address that.
Yes, Your Honor. I believe Officer Jatef and her colleagues that were also involved in these off-duty relationships that were being paid for these services, they were the ones who were awarded with, using your parlance, Your Honor, of the benefits of the master contract. Some of those expansive scope of this master contract necessarily requires that the general contractor and its subs create an environment where the workers can physically work on these lanes, and part of that is obviously closing the lanes so that the workers have a practical ability to perform their work and also safe and do it in a safe way. And that was the specific contractual duties that were sublet to FHP and its troopers that were all engaged in these off-duty activities as paid for.
Council, I have just a couple of quick questions. You would concede, wouldn't you, that just the one-page request on its face by itself with no other facts surrounding it about what was going on here, that just that document in and of itself is insufficient to establish a contract? You'd have to look at the other circumstances about who gets paid, how much they get paid, all the hours. It seems like the essential terms of the contract are not just in this one page. Would you agree with that?
In so far as if you only look at the one-page document, Your Honor, I think you can certainly make the argument that it's insufficient from all the terms, not necessarily essential terms, I would say, all the terms that were practically necessary to just get the nuts and bolts of who was being assigned to where and when and for how much, Your Honor.
Okay.
And
go ahead.
Yeah, and I believe the case law is very clear that that isn't those kind of terms are not necessary to create a statutory employer relationship. I believe the case law, many of the cases are very clear that in fact it's not necessary at all. I would point you to the Antonelli versus Ocean Suite hotel case, and out of the first district, 1994. That's where the first district found that it was, quote, immaterial whether or not a formal written contract existed between the hotel in that case and its guests concerning the meals being provided in the hotel restaurant. And it found that to the extent the hotel had an obligation to provide a meal to its guests based on the guest package that it offered, the hotel delegated its or sublet its meal duties to the restaurant. And it found in that way the statutory employer for the restaurant worker who was injured on the job was in fact the hotel, who had no formal written contract at all with that restaurant or its worker.
Okay, well, yeah, the trial judge's order seems to suggest that there's, quote, undisputed record evidence that establishes a contractual relationship. And she also went on to say the record evidence establishes that there was a, quote, written agreement for traffic control services end quote. So the written agreement she's referring to, would that just be this one page, or are there some other written materials that she might be referring to?
No, as far as the written agreement itself, Your Honor, that is the sum total of the written agreement. I
Okay.
believe the. Go ahead, Your Honor.
No, I was going to move on to something else. I have one more question.
No, I would simply add that the remainder of the contractual terms were developed in the record evidence or provided to the court and reviewed by the court, and in his final decision, in that this was an enforceable contract that provided these type of sublet obligations onto FHP and onto its trooper JTF.
Okay, factual question, what you may or may not know it. Who paid for the damage to the FHP vehicle?
I'm not sure, Your Honor. That I'm not sure is in the record.
Okay.
The property damage. This case solely relied on the tort claim from Officer Jadef regarding the workers' compensation immunity.
I mean, I guess obviously the driver, was it Mac? He's covered by the workers' comp from Halifax, correct?
Yes, Your Honor.
Okay. All right.
And I would say my understanding of the statutory scheme is that the statute, workers' compensation statute, requires that the statutory employer ensure that any kind of statutory employees are covered by workers' compensation. In here, the record is clear that Officer Jadef was covered by her own employer's workers' compensation scheme, and then there's no similar obligation that requires subcontractors to confirm or obligate them to confirm the workers' compensation coverage of other subcontractors. That's not an affirmative obligation that subcontractors have with their other fellow subcontractors on a job.
One other question. What are we to read into the provision of the one-page document that says employer will or will not be responsible for providing workers' compensation coverage to FHP members? Here it was checked will not. There's a box that you can check to say will. It seems to me maybe that has some significance, because if the employer is saying we will not provide coverage, it is at least a little bit of indication that they don't believe that this is a subcontract.
Your Honor, I think is the fact it matters that there is some obligation by Archer Western if the JTF had not been covered for any reason by her actual employer, FHP, their workers' compensation program. I believe that would impose an obligation on Archer Western to provide her a workers' compensation coverage in that instance through the statutory scheme.
Once a subcontractor contracts with Archer here, like FHP contracts with Archer, isn't the subcontractor required to file like a certificate of work comp insurance to show that they have work comp insurance? Do you know if that was ever presented in this case, that FHP had provided that to Archer to show that they were actually a subcontractor?
Your Honor, I'm not positive. I think it is, but I can't say definitively. There was a number of hundreds of pages of documents submitted to the trial court in pursuit of summary judgment, and the trial court referenced.
If that's not in the record, would that be important to show that they were not a subcontractor?
I don't believe so, Your Honor. I believe it's all about the obligation to provide workers' compensation coverage directly up the line in the vertical stack to the statutory employer. In this case, that would be Archer Western.
Well, they have as Judge Makar pointed out, their request for services say they're not going to provide this. So that onus would have fell on FHP. So they would have needed to provided that workman's comp certificate to Archer, correct?
I believe so, Your Honor, but I also believe that the statute would have imposed an obligation on them regardless of if one of their subcontractors had failed to provide workers' compensation for one of their workers. Archer Western, as a statutory employer, would have had an obligation to provide coverage for those statutory employees of one of its subcontractors if something had fallen through the cracks. Now, I think some of the issues here is that even if this court had issues with the sufficiency of the detailing of the request. I think the record is very clear. The factual record is certainly developed enough that to find that this under the Florida's workers' compensation scheme was an implied in fact contract, and that is more than sufficient in the terms of workers' compensation law in Florida and in the case law to obligate and create a contractual relationship like that. I will point to two cases, Your Honors, that was in the briefing. The first is the Pickwick Food Stores versus Tensor case. That's the second DCA of 1981. And that dealt with a contract that gave the company the right to conduct retail sales of gasoline on the premises of a convenience store. And the second DCA found that this contract was void for lack of mutuality because the gas contractor could have pulled out any time, regardless of the obligations of the convenience store. But I think even in this case, everyone would agree that if there were sales of gasoline made at the convenience store whose profits had not yet been distributed, either party would have had the right to enforce the agreement with respect to distribution of profits. And I believe that's the exact scenario that was in the Pullum versus Hercules case out of the First District in 1998. In that case, a company contracted with a landowner for the right to remove tree stumps from the property. And there was no obligation to remove the stumps at all. It was all on the company, the tree removal company. An employee of the company was injured while removing the tree stumps. The lower tribunal determined that there was no mutuality obligation, and therefore the landowner was not the statutory employer. But the First District found that even if the contract itself, the master contract, was not binding upon inception, at the time of the injury, a number of the tree stumps had already been removed and loaded, and therefore the landowner could have enforced the terms of the agreement at that point by demanding payment for the stumps. And because the contract had already substantially been performed.
Counsel, I'm sorry to interrupt, but your time's run up, but I want to get one more question in.
Yes, Your Honor.
It seems an oddity here that where is FHP? They're not a party in this case, yet they're party to the contract. And do we have any clue from the record in this case about what FHP's position is on this legal issue?
No, Your Honor. We have affidavits submitted, I believe, in opposition to summary judgment about just the general framework of the arrangement. And they confirmed that, yes, JTEF was presented with and accepted the assignment on the night in question to work alongside Halifax for the benefit of Archer Western. So they have been involved in the case as presenting factual evidence and sworn testimony by the way of affidavits, but they are not a party. I believe that's just the function of this was a tort claim where Archer Western, or I'm sorry, Halifax and Rodney Mack had asserted workers' compensation immunity as an affirmative offense. And therefore, it's really all about immunity from Officer JTEF's affirmative tort claims. And I apologize, I see my time is up. So I would simply respectfully ask that the court affirm the trial court's summary judgment order.
Thank you, counsel. We'll have rebuttal now.
Thank you, Your Honor. I want to emphasize that this implied contract theory that Mr. Rodabout's arguing today, that was never raised in either of the defendant's motions for summary judgment or considered by...
Was there evidence in the record that a master trooper executed the request?
The request for police services?
Yes.
Well, there's a signature on it with a box checked.
Was there evidence presented that Officer JTEF accepted the off-duty assignment?
That she took a shift, yes. But
that she knew she was going to be paid by Archer for that shift?
Well, presumably. We don't have any evidence of what discussions were about pay. How she testified that generally they're paid by the private company, but we don't have any evidence about what was explained to her beforehand about how she would be paid, what the rate of pay would be. And this whole theory that maybe there is some implied contract that developed outside of this request, it was never presented below for Ms. Jada, for her counsel to respond to. And this is why courts, including this one, have held that the Tipsy-Coachman doctrine does not apply to grounds that are not raised in a motion for summary judgment. In my reply brief, I cited the third DCA's case, Galoo versus Clopay Corp. For that point. And that case is also significant because that was a workers' compensation case where on appeal, the defendant, which claimed to be the statutory employer of the injured worker, could not establish that, couldn't defend the ground on which summary judgment was granted in their favor below. The contract clause that they have relied on in the trial court simply did not impose the obligation that they claim to have sublet to the worker's employee. And so on appeal, they shifted, they tried to base it on a different clause in the contract, and the third DCA rejected that. And this implied contract argument we're hearing today, it's similar to that. And it's important because when a motion for summary judgment is filed, it has to give notice to the non-moving party of what the grounds for the motion are so that the non-moving party can respond to it. And so here we're hearing for the first time on appeal a theory that was not argued in either of the appellee's motions and that was not considered by the trial court. The trial court's ruling is based entirely on the premise that this one-page request for police services was a contract between FHP and Archer to provide however the trial court characterized the services. And it simply was not. Mr. Rodabaugh, he practically admitted today that this page, standing alone, cannot be a binding contract. And of course it can't. It would be, I'm sure, as the court pointed out, FHP isn't here today, but I'm sure they would be outraged to hear that every time they just check approved on one of these forms, that they have committed themselves to provide however many troopers the private employer wants, or else FHP will be sued for breach of contract if one night not enough troopers sign up for that shift. Also, Mr. Rodabaugh claimed that police services are carved out of this request. They are not. He's referring to a line that says, "I understand that during the course of the troopers' off-duty police employment, the Florida Highway Patrol may make a..." Okay, it's the wrong one, but I've discussed this in the reply brief. Police services are not carved out of this form, that they are actually, the whole purpose of this form is to provide police services. The patrol vehicle required box is checked. It's titled "A Request for Off-Duty Police Services." This is about police work, not construction work.
Well, thank you for your presentation. We thank both of you for your presentations today.
Thank you.
Court will be in recess.
Thank you.
Thank you, Your Honor. Thank you, Shay.